of what AB5 looks like in the California space. Greg, thank you for joining us. And before we get into the interview, can you give us a little bit about your background and how you know so much about what this means for trucking?
Sure. I'm the president and managing partner of the Scopelitis law firm, and we represent transportation across all segments across the United States with offices all over the United States. It's all we do. We believe we're the preeminent transportation law firm in the United States. So sorry for that shameless plug, but that you asked.
And Greg, let's just jump into it. I mean, we're looking at this decision right now. What are going to be some of the ramifications? Who's going to be enforcing this? What does this all look like?
Well, if you, from the highest view you can get, I would say a couple of ramifications. The first being that there will be less truck drivers in California. And anybody that follows trucking knows that's not a good thing. There's not enough as it is already. There's congestion, supply chain problems. It's a major shipping entry for the world and for the United States. So it's not going to help matters when this law takes effect, which will be soon in the next day or two. It's a law that was actually enacted in January 1st of 2020, but it was stayed a few weeks thereafter in a court challenge by the California Trucking Association. And it made its way through the Ninth Circuit. Ninth Circuit ruled against the California Trucking Association. It was appealed up to the Supreme Court. Supreme Court yesterday denied hearing that appeal, which turns the law back on. And what it means is that all those small businesses, those owner-operator independent contractors that are operating in the state of California under the authority of a motor carrier could readily be deemed to be employees rather than independent contractors. So in effect, it takes their small business away from them, and it places all of those motor carriers using those small businesses in jeopardy of being in violation of wage and hour laws in California, workers' compensation, and unemployment tax laws in the state of California. So it puts everything in quite a bit of peril.
So with this, the original intention of AB5 was to make sure that some of those gig workers were covered and protected. And the reasoning why people in the trucking industry were so concerned is because the language is very broad in the law. It's very broad, and it allows for some overreach into these industries where it might have these unintentional consequences. Can you talk a little bit about that specific language that makes it so broad? We broke down the ABC test a little bit earlier, but what is kind of the reasonable reach of the language in the law, and how can it now be interpreted to affect the trucking companies?
Well, actually, the law was written by the then California legislator, Lorena Gonzalez, and she did intend for it not just to be targeting Uber and Lyft and DoorDash and the gig economy workers. She was specific that she also wanted it to target the trucking industry. She's now left the legislature, is back in the organized labor segment. But what happened was this law applied to all industries and all businesses in the state of California, except for those that were exempted from the law. And then there was a long laundry list of business industry segments that were exempted, the financial sector, real estate, journalism, and on it goes. But trucking was not one of those. Interestingly, you mentioned the gig economy. Uber and Lyft and DoorDash struck out on their own to put Proposition 22 into the law in the state of California. I think it was back in 2020 or 2018, in that time frame, where a referendum was put in front of the California voters, and they voted, I think, by about 58% to have Proposition 22 become law. And it does, in fact, exempt gig workers from the application of AB5, with certain conditions put on it. So what it was designed for, to some extent, it's not regulating at all, or at least a big portion of the gig economy. But it was also designed to regulate trucking. And what it does is it puts into law something that's never been in California law. It's referred to as an ABC test. And it's a 3-prong test. In order to prove independent contractor status, all 3 prongs would have to be proved. Prong A is you would have to prove, you've got it up on your screen, that's great, that the worker is free to perform services without the control of the company directing it, the motor carrier. I'm going to jump to 3 there, that the worker is in a customarily independently established trade, occupation, or profession. It's number 2 that causes the greatest challenge, which is that the worker is not in the same trade, occupation, or profession as the company that's using that person's services. So when you think about truck drivers working for motor carriers, like I said, it's a challenge to prove that the truck driver is not in the same trade, occupation, or profession as the motor carrier. There is a 2019 Indiana Supreme Court decision that does end up concluding that driveway drivers, those that get into recreational vehicles and deliver them to those who have purchased them, working for the driveway company, did pass the ABC test and were deemed to be independent contractors, but I'm not sure that kind of decision would necessarily be followed in the state of California by the California judiciary.
And Greg, when I think about this kind of going into effect, businesses are going to react. And this is how it is kind of coming from an economic standpoint. You put something into place, people are going to react and really find a way around it. Are there going to be any types of loopholes that you think are going to be common practices to kind of get around this new changes that's going to be happening?
That's a great question, Anthony. And I'm not sure I would call them loopholes. I think that feels a little manipulative and tricky. I think it's just going to be straight up the industry reacting to what California law has presented the industry. Some in the industry will stop doing business in California. Some in the industry will try to hire employee truck drivers. I think you Kaylee, and Anthony both know there's been a driver shortage in trucking for a long, long time. COVID certainly didn't help that driver shortage get lesser. It's even gotten greater. So you could see drivers leave the industry. I think we've seen that. Some companies will change their business structure, try to operate more as logistics companies, freight forwarders or property brokers. And there's a number of other workarounds, all of which I think increase the cost of the delivery of goods. And that over time will ripple to consumers. And, as we sit here at the cusp of possibly a recession in 2023, this type of law doesn't help us at all. It has the realistic chance of increasing the price of goods, and that hurts all of us.
Absolutely. That same sentiment came from the response from the California Trucking Association, and they immediately called on Governor Gavin Newsom and the legislature to do something about it. Greg, we've only got about a minute left, but is there anything that the state legislature can do to redact this or limit the power that it has on the trucking industry?
I think there's been some attempts to try to do that. So far, not successful at all. I don't know that I've seen anyone forecast a good chance of a legislative fix on this. It's just the nature of the politics of the state that they're leaning towards worker protection laws, not entrepreneurial protection laws. And I think that's so hope springs eternal, but I don't see that happening in the near term.
Excellent, Greg. Thanks so much for joining us this morning and bringing that legal aspect for this situation so far. We'll be continuing to follow up with you as the situation develops.
Okay, thank you very much, guys.
Absolutely. Good to have that last rounded out perspective as well to follow up that conversation today.